Honorable members, today we intend to resume and conclude our deliberations on the appropriate penalties. We have heard the arguments in aggravation and proposed penalties that were presented by the initiator yesterday. It is time for us to deliberate on the appropriate penalties, taking into account the aggravating factors put to the committee by the initiator. The floor is now open for you members. I will request that my staff members assist me with identifying names from honorable members.
Madam Chair. Madam Chair.
Maybe speak on just unmute myself.
Madam Chair.
Can you hear me?
Yes, I can hear you.
Chair, we have received a letter from the attorneys of the affected members. The initiator would like to speak to that briefly, Chair.
Okay. Let me allow the initiator to speak to the letter. Letter from which group?
Thank you, Chair. This is the initiator. There seems to be an echo in this room, so it's very difficult to...
There is lot of noise. IT, can you assist us?
IT?
I was thinking, where does the letter come from?
Yes, but Chair, the letter is a letter from the attorneys for the affected persons, and attached, and it's sent to the state attorney, and it's attached to it are written submissions from the Honourable Member Malema MP, and it's a written statement on behalf...
There is a problem with sound. Can you hear me, honourable members and our officials?
Yes, we can hear you, Chair, but we can't hear from the house. Thank you.
Okay. Can you please fix the problem so that we may proceed?
Until now, it came at 7:36 this morning.
From?
From
Chair, can you hear me now? Chair?
Yes, we can hear you.
Okay, so Chair, perhaps I should continue. At 7:36 a.m., that's this morning, a letter arrived from in Levitt attorneys, that's Ms. Cupido of the firm in Levitt, and it was sent to the state attorney, and then there were various other persons CC'd, myself, the legal advisor to Parliament, etc. And attached to the letter, attached to the email, or attached to the letter, was a document in Word from which consisted of a written statement on behalf of the charged members of Parliament, and it was signed by J.S. Malema MP, and is dated 21 November 2023. And the effect of the email from in-Levitt attorneys is that this written statement on behalf of the charged members of Parliament by Mr. Malema, Honourable Member Malema, ought to be taken into account by the committee before the committee makes a decision on guilt or otherwise. It doesn't deal with sanction at all. And so perhaps I should just read a couple of the paragraphs. It's 14 pages. And paragraph 1 says, this is a statement on behalf of the economic freedom fighters and its 6 members of parliament who have all been separately served with charges that are identical. And then they quote the charges.
Sorry, initiator, sorry, advocate, that we can't hear you well. Can't the data be flagged on the screen so that honorable members may be able to follow? Even myself, I don't hear you when you are breaking. I just hear the affected members.
Understand.
But it is not clear on what is it all about. So maybe if you can be assisted that the letter be put on the screen so that we will follow you while you read it for us.
Yes.
Then we will take it from there. For now, it is going to be difficult for us to follow everything because we don't have a letter before us as members of the portfolio committee.
Chair, I think that's a good idea. I just want to check with those who assist the committee whether they can do that. I think they're trying to do that. Can I, Victor? Yes, I'm told that they are. I think he's doing it now. It's 14 pages. There we go.
It's 14 pages.
It's 14 pages, and it's a statement by Mr. Malema, Honourable Member Malema, and perhaps the last paragraph should just be read, because what it seeks to do is to ask the committee to find them not guilty. Because they say they listened to the evidence of the secretary, they saw the video which wasn't authenticated, and they say their rights to freedom of expression trump. And perhaps I should just read the conclusion as to what they say. They say, on the evidence, or no, when I say they, it's Mr. Malema on behalf of the EFF and the 6 members. He says, on the evidence presented to the committee, 29.1, there was a peaceful protest. Violence emanated from the speaker. Some of the members who assaulted EFF members carried guns on them. 29.2, no case was made out that the conduct in issue amounts to misconduct as per the charges. No case was made out about the threats experienced by the speaker, the chairperson of the National Council of Provinces, and the president. No case was made out there had been a breach of the rules. And the conclusion in paragraph 30 from Mr. Malema is, we submit that the committee should find the EFF not guilty on the evidence presented and on the common cause facts. Signed, Julius Malema, MP, and that's page 14. And in the body of the document, the thrust of it is twofold. One is the video that was shown wasn't authenticated, and 2, there is no evidence that the president, the speaker, or anybody else felt threatened, and that all effectively that they were doing in storming onto the stage at the time they did was to exercise their constitutional right to freedom of expression and freedom of association by protesting with placards in the way that they wanted to against the president and the various aspects that they claim vitiated the president's ability to talk neutrally to them, including, for example, what they would call the Palapala saga. So Chair, there are two issues that I wish to raise. First, the document came in this morning at 7:36 a.m., and the Chair, you will recall, and the committee members will recall, that yesterday there was a request from the attorneys, Ian Levitt attorneys, to make written submissions by close of business yesterday. That request was rejected, and the committee went on to consider the matter and decided within the committee's power that the 6 different members were guilty of the charge that was put to them. And we will submit that the Latin tag functus officio applies. In other words, once you made your decision, once the committee made its decision, it was the end of the matter on the question of guilt or innocence. And it was too late after that for anyone to come along and say, well, we shouldn't be found guilty for this and that reason. It's too late. That's the first submission. So this committee is functus. But secondly, and in any event, if one has regard to the submissions made on behalf of the 6 affected members, the submission from the initiator is they have no merit. it cannot be suggested that freedom of expression under the Constitution or freedom of association under the Constitution includes the kind of conduct which was displayed during the SONA 2023, as the Secretary to the National Assembly explained. It was abrupt, it was stormed, it was unauthorized, and it was clearly, objectively seen as a threat. It didn't, and to the extent that any person felt or didn't feel that it was a threat is irrelevant. It's an objective inquiry, as I argued yesterday, and as this committee accepted, the conduct clearly violated those provisions of Section 7 of the Powers Act, as well as the various rules that are contained in the charge sheet. And there's nothing in this written statement that we would submit has any effect on the question of the charges and the question of the cogency of the evidence that led to the charges being upheld. So we would say for those two reasons, the committee, as it must do, get on with the question of sanction. And the chair, you will recall that I argued sanction yesterday, and from our side, from the initiator side, there's nothing further to say, other than the committee may now, or has a duty to get on with what you, Chair, directed, which is to get on with consideration of sanction. I'm available to answer any questions on sanction, to supplement my submissions that I made yesterday, but I stand by those submissions, which were based on the various provisions contained within Section 12, Sub 5 of the Powers Act. Thank you, Chair.
Thank you, Initiator. I wanted us to be clear where the letter comes from, who's writing to us, because my understanding is that on the 20th November, the affected members stayed out and utter words that they can't sit before us as they were a kangaroo court, and the legal team was also instructed to leave by its affected members. So I don't know from the members of the committee, here's the letter before I'm chairing the meeting, but I'm just highlighting that maybe we might have forgotten about what happened on Monday. So that, honorable members, can you make some input? You are not discussing what is in the letter, about the letter itself. We've received this letter. The Parliament, our legal team from the Parliament has received this letter. So they are bringing it for our attention. What is your view on this matter, so that we can be able to proceed? Thank you. Please assist me by identifying hands from honorable members.
Dr. Lotrit, the Deputy Chief Whip of the Majority Party, and Mr. Kaba. Thank you, Chair.
Thank you, Dr. Lotrit. Deputy Chief Whip.
Thank you very much, Honorable Chairperson. Good morning to everyone on the platform and also our initiator and those in S12A. Honorable Chair, I just want also to echo the sentiments by my colleague, Honorable Lotrit, saying that we started with the hearing on Monday. We were all here in the meeting when they insulted us. They decided to withdraw and also withdraw their legal team. So we are not going back, Honorable Chair. We have passed that stage. We are here now discussing. We will be taking a decision in their absence, of course, because they elected themselves to leave the meeting, the hearing, calling all sorts of names. So we are not going back, Honorable Chair. We have passed that stage. Thank you.
Thank you, Honorable Deputy Chief Whip. Honorable Kaba.
Thank you, Chair. Chair, I think this is so surprising that we'll be receiving letters, except having said that, which is also indicating what the outcomes must be of the committee, which we have not even arrived at. Really, I don't want to say this letter is blaspheming to us. And I think I joined the other colleagues that we have taken a decision and we are proceeding accordingly as per your guidance, Chair. This letter, indeed, as it is outlined to us here, Chair, I think it doesn't serve a purpose for now. We are having duty to do here, and we are assigned with task, which we are ready to do as we proceed. Thank you, Chair.
Thank you. Do you have any other hands? This was the only hand. Thank you, honorable members and honorable members and Advocate Gazi for the advice. Indeed, we can't have predetermined outcomes before the committee exercise its mind. So I will allow the members of the committee to exercise its mind based on the presentation by our initiator. As I have indicated, we can't go back. I believe we need to respect each other. This process is a formal and legal process. I believe we need to take ourselves serious and also to consider the rules of the House. So in that order, we'll be proceeding. The letter is for noting because indeed we have passed that stage. I will now invite hands, honorable members. Thank you.
Honorable Chair, thank you very much. You are chairing. I'm sorry because Honorable Lotrit was first, but I'll get in as you have identified me. Thank you very much, Honorable Person. I want to agree with my colleague. Honorable Chair, you cannot choose to participate in a meeting, then sitting outside, you send a letter dictating to the very same meeting that you were supposed to be part of to say this and this shouldn't happen. The people who are sitting in this particular meeting have their own minds. They have their own advisors, parliamentary legal advisors, and also we have the initiator who's always assisting us. So it cannot be fair to us to say that we shouldn't find anyone guilty or we shouldn't do this, we must do this way. No, that is not how it's supposed to be done. They elected to leave the meeting. They elected to also inform their legal reps to leave the meeting. So we have passed that stage now. As a committee, we deliberated on the matters, and here we are now. Ours is to discuss the sanctions. And the sanctions as proposed by my colleague, I think that is what we should focus on. An apology to the President of the Republic, to Parliament, and to the South African citizens. That will be a better sanction, and also a 1-month salary. Doc, that I think will be a better sanction for these for what the honorable members did. I think I'll stop there for now, Honorable Chair. Thank you.
Thank you. Sorry, Dr. Lotri. The stage is yours.
Thank you, Chairperson. We have now found these members guilty. And we have also come to the conclusion that there are serious aggravating factors. Their behavior was egregious. And I would therefore, when we look at the sanctions, and I must also add that I've been a member of this committee since 2014, and have gone through many iterations of what we have been doing now. And I have to be honest that just giving a fine has not really had the desired effect. So, Chairperson, I would propose that given the type of behavior that we witnessed in February, that we combine the initiator's proposed sanction, namely the apologies, with the one made by Honorable Mlenzena, in other words, the fine. But I would strongly argue that we also impose a sanction or a suspension on those members for a period of a month. And given the time we are in now, it is the end, this still has to go to the NA for a final approval, that we make the whole suspension for the month of February. Thank you.